Real life.
Yeah, right. Thank you. Eric has a new draft. I'd like to requote Harry Chen, interim commissioner at DCF. I said, running DCF without a secure facility is like running a hospital without an ICU. You will see one of the changes in the bill is a report on secure facilities.
Senator, shall I share the screen for this one? There's it might help.
I think it would help probably people who may be online. Oh, that's recycled. I'm sorry, Eric, I've got to take care of.
Don't worry.
I don't know. This is recycled. Trying to do my part for the environment. By the way, I'll mention it, but everybody's here. But why don't we start with section 1?
Sure. Good morning, everybody. This is Eric Fitzpatrick from the Office of Legislative Counsel, here to walk the committee through a new version of the proposed committee strike all amendment to S4. This is version 3.1 dated this morning at 9:05. So make sure everyone has the same version to look at. It's on the screen as well. And as you indicate, Senator Steers, section 1, the first, and the section 1 itself is highlighted because this is actually a new section in the bill. And it has to do with the issue of, you remember, this is the issue of transfer between the family division and the criminal division in juvenile cases. So just for a moment to refresh everybody's recollection, remember that when a case is filed against a juvenile, where it starts depends on not only the age of the juvenile, but what kind of case it is. So if it's a Big 12 case, remember it starts in the criminal division. And if it's not one of those Big 12 felonies, then it starts in the family division. So what this provision deals with, as you can see from line 7, 8, and 9 that are highlighted, is a transfer from family division of the Superior Court. So in other words, even if it's a non-Big 12 offense, which means, remember, it has to start in the family division, it can still be transferred up to the criminal division, right? It all depends on how old the person is and whether it's one of the offenses known as the Big 12. So you've seen that this is existing law, the first paragraph there, it's talking about the age range of the children that could get transferred to the criminal division. And again, line 13, for example, if the child is 16 but not 19, that means 16, 17, and 18-year-olds, and it's not line 15, not a felony specified in 1 to 12. That means so if it's a 16, 17, and 18-year-old, or 18-year-olds, right? And it's not a Big 12, it has to start in the family, but it can transfer up to criminal. Everybody remember that option, that transfer up is what's sometimes called. So the reason we're looking at this section is, you remember the committee discussed last time, should the Big 12, well, 2 reasons really. One is, should the Big 12 be expanded? That's one reason you're looking at it. And the second reason you're looking at this section is because this is where you would address the ping pong under the proposal that you looked at last week from Attorney Marshall Paul, which I have rewrote a little bit and folded into this section. So those are the 2 things to think about as we look at it. So the first one you'll come to is, all right, the existing Big 12 is not highlighted, but the highlights are what you've been thinking about last week as possible additions to the Big 12. So should we just look at those as we go through? And I should add one more thing. Once we, you remember that when you were going through the proposed list of possible Big 12 additions from the administration, there were some that you said, we're okay adding this, and there are others you said, we don't feel comfortable adding that. So the proposal here at the very end of this bill is for those that are not in right now in this draft to add to the Big 12, those are all put in a study for the Vermont Sentencing Commission to look at and say, to take more time to think about, hey, should these offenses be added to the Big 12 too? So in other words, no decision made here at this point, But, and I'll spin forward real quick and I'll come back to the top, but I'll just spin right to the bottom so we can see, you can see that other possible plan for these other Big 12. See that? So it says it's on page 21, section 15. Report by the Sentencing Commission. So on or before December of this year, Sentencing Commission shall report to Justice Oversight as well as the Judiciary Committees on whether the offenses for which transfer from the Family Division to the Criminal Division should be expanded to include, and in that list is the list of offenses that were on the administration's proposal that the committee did not want to add yet to the Big 12 in the current bill. Does that make sense? Everybody understand what that is? So obviously, this is just the next draft. You can certainly move it back and
If the committee
forth.
wanted to, they could take 17 and 18.
Yeah.
Okay. They could take 17 and 18 and study that as well, and take it off.
Yeah, whatever you want to do.
I'm not clear, isn't an attempt automatically? I remember having that big issue about attempts, and they,
Does it automatically
every
qualify as a
few
Big
years,
12?
it automatically qualifies. Attempted murder would automatically qualify as a Big 12 offense, would it not?
Without stating so explicitly, that's a good question. I don't know.
I'll give you my opinion, which is that it does, because Vermont, because of the way that Vermont treats attempt, we have a separate statute for attempt, so you don't get charged just with attempt or with a charge called attempted murder. You get charged with the charge of murder and the separate charge of attempt. And so from our perspective, there's no problem with including attempt on this, because from our perspective, that's already been the law. So we have no objection to including attempt on here.
Okay, thank you. Those martial calls.
So now we're going to spin back up. So that's so you know that that's sort of the proposed structure here. Some proposals to add to the Big 12, but there's also a proposal to have other possible inclusions studied, and you can certainly offenses back and forth between the categories if you want to do that policy-wise. So the first proposed addition is in addition to the murder on which is number 5 of the Big 12 on page 2, add aggravated murder.
Yeah, that was.
Second one, line 11, existing law,
I
existing.
think everybody's agreed on that, because there are changes in the law that occurred after the Big 12 was invented.
Yes, same with the next one. Right, exactly. And that's also true with the next one, number 11 of the Big 12.
Right.
Aggravated sexual assault is in there now. Aggravated sexual assault of a child was a newly created offense after the Big 12. So that's the proposed addition. I move on from that one.
Yeah, number 13, I thought we wanted to put in some language indicating that it would not be a felony if it was, for example, who knew what the plate glass window was worth that the person throws right through?
That's in there, but that's later in the bill. That is
Oh,
there.
okay.
Yeah. Yep. So 13, 14, and 15, you may recall, those were actually in S4 as introduced. These are the ones that were in the original version of the bill as essentially additions to the Big 12. At the time, it was not just a firearm, it was a dangerous weapon, because that's what the offense is called in 13 VSA 4005. But rather than, since you're possibly expanding the Big 12 anyway, from a drafting logistical perspective, it made more sense to just include them here. If you're gonna, you still have a policy decision about whether you want to include them at all. But as far as where to put them, that's where they, so they remember they were the first section of that original S4. And those are carrying a firearm while committing a felony, trafficking a regulated drug, and human trafficking or aggravated human trafficking. So the last 3, 16, aggravated stalking, not stalking, the straight up stalking misdemeanor, but aggravated. An attempt, this is what we were just discussing, so number 17, And lastly, number 18, a violation of a condition of release for any of the offenses listed in this subsection. My understanding of the reason behind that proposal is that if you think about, generally speaking, a violation of condition of release offense would not be a Big 12, right? That would be an offense that would go straight to the family division because it's not listed among these offenses. So if you have someone who is in the criminal division for having committed one of these big, whatever, 12, 13, 14 offenses, whatever you ultimately land on, if someone's in the criminal division because they've committed one of those offenses and they violate their condition of release, the concern is that the violation proceeding would have to go into the family division, even though the criminal proceeding is in the criminal division. So the proposal here is to make sure that they stay in the same proceeding so that the violation of conditional release for one of these offenses would also be in the criminal division along with the underlying offense.
Okay,
Can I offer a thought on that piece?
yeah, if you could identify yourself for the record, please.
Yes, Senator, thank you. My name is Jared Bianchi, Bennington County Deputy State's Attorney. Just wanted the committee to be aware that I think the original language was a condition of release imposed by the criminal division. You should be mindful that I think at another point you were talking about transferred cases. There could be felonies that are transferred from the family division to the criminal division. And you could be setting up, if you limit it to just offenses listed in this subsection, to a case that has otherwise been transferred out of the family division to the criminal division. And you might not want to be setting up the inability of the criminal division to police those conditions in a case like that.
Thank you.
Could I follow up on that point with what
Yep.
occurs to me that I see that point. The case has ended up there by transfer. But what if sort of the opposite side of that would be some of these cases conceivably could be transferred back to the family division for youthful offender treatment. Is that right?
That's right. And the way that the youthful offender statute works is once the family division accepts the case and enters its own conditions, the criminal division's conditions of release are no longer there. So the statute already addresses that circumstance. Pretty neat.
Okay, thanks.
Thank you.
I would just like to add a clarification to that point. I think there's differences in practice. That may be how it happens in Bennington County. I'm aware that there are some distinctions around the state and how this actually plays out. I think that in most counties in the state, what's happening is that the conditions imposed in the criminal court are remaining in place while the person is seeking youthful offender status, and even after they've gotten youthful offender status. And in fact, violations of those conditions are dealt with in the criminal courts typically, and then it's the only once they switch over and are put on probation and their conditions of release end and their conditions of probation begin, that the family court's jurisdiction over those conditions. So I think this is just variation in practice around the state, because certainly there's parts of the state where even while the case is even while the youthful offender part of the case is happening in the juvenile division, it's still those criminal court conditions that remain in effect sometimes for quite a lengthy period of time.
So maybe to address that possibility, because I've been thinking this anyway before Jared's response, to add, in addition to, if you're gonna add, or a case that ended up by transfer from family division, or if the underlying case is still in the criminal division, something like that.
I've got it.
Right.
I'm going to address it.
Yeah, thanks. All right. Any other discussion on the issue of Big 12 expansion before moving to the ping pong?
No, I'd love to get to the ping pong.
That sure does sound like more fun.
Big 12.
Is there any chance to just, when we were discussing this before and I testified on it, there seemed to be some support from the committee around concerns around particularly adding human trafficking. I had pointed out that literally, I mean, we're talking about 14-year-olds here. Literally any 14-year-old who has committed the offense, committed the elements of the offense of human trafficking they're a victim. They are not themselves a human trafficker. And that was the reason why we felt that should not be in the Big 12 at all. And to the extent that it is, it should be in some way limited, maybe by age. But the real issue is when you have a 14-year-old, even if they have committed all the elements of human trafficking, they're a victim, and what they need is not the publicity and punishment afforded by the criminal courts, but they need the confidentiality, treatment, and security afforded by the juvenile courts.
As I was originally drafting the bill with Eric, we had 16 on all three of those editions instead of 14. And then I looked at it and thought, well, to be consistent, it should be 14, but I have no objection personally to going back to 16 for particularly particularly the human trafficking.
And our office had focused on the human trafficking part of it just because that's where we've seriously come through our records to try to find cases of 14-year-olds who were actually human trafficking and couldn't find evidence. We found people who were victims, not perpetrators.
I would have no objection to this if they were age 16. Maybe.
So for that one in particular, the human trafficking, 16 and above.
Yeah.
So moving now to the ping pong. So for a moment of background about that, remember the section that we're in here is transfer from family division, right? That's what we're talking about. This Big 12 and possible additions to it are cases in which if for example, a 16, 17, 18-year-old commits an offense that's not a Big 12 offense, that has to start in the family. But there's this possibility that it's not one of those Big 12 or Big 14, whatever it ends up being offenses, that a motion can be made to transfer that case to the criminal division. Right? Now, in that case, it would be a criminal matter. But let's say that it appears to people involved in the proceedings that it might be better treated as a youthful offender case. Problem is that the ping pong issue is that even though the youthful offender case is in the family division, it has to go to the criminal division first. It's one of those non-Big 12 offenses. And then what's known as a youthful offender consideration hearing has to take place. And then that hearing has to occur. And then there's a decision about whether or not the youthful offender proceeding occurs. So you have two separate hearings. You have this one right here that we're looking at, this transfer hearing, which is now we're on line 6. This is an existing law. Line 6, state's attorney may move in the family division for an order transferring jurisdiction at any time prior to adjudication on the merits. And this transfer would be to the criminal division. And upon the filing of this motion, this is again existing law. You see it in subsection C. You'll see why this becomes important in a moment. There's a long list of criteria that the court has to consider in this transfer hearing, whether or not to transfer this otherwise family juvenile matter up to the criminal division, right? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 13 different criteria the court is meant to consider. Transfer terminates jurisdiction of the family division within the criminal division. So again, reminding you, if that hearing is, or if the motion is granted, if the petition is granted, that means it moves to the criminal division, and that's the only way, other than a direct file, which is a separate issue. But if it's one of these misdemeanor cases, in order to get it into the family division for youthful offender treatment, a separate hearing is going to have to occur, this youthful offender treatment hearing. The proposed ping pong is to cut out that second hearing, cut out the necessity for that second hearing. So you see, this is in at least on my version, it's page 5, subsection F1A and B. So F1A is existing. It says, all right, the family division, after the completion of this transfer hearing, which is what we're just talking about, has to make findings, that the court orders transfer from the family division and for reasons, then it orders transfer and the child is treated as an adult. So that's all in the family division's first step, right? The proposal is to provide the family division with another option. Family division orders transfer of jurisdiction pursuant to this subsection, right? So, okay, they've ordered transfer to the criminal division, but line 18, it appears to the court that the child may be amenable to treatment as a youthful offender. Now that language is intentional. That's because that's one of the, I'm sure Senator Sears will remember this, that's one of the criteria that the court ultimately has to find, amenability to treatment as a youthful offender. So if it appears to the court right away, hey, it appears that this child could be amenable to treatment as a youthful offender, the court may proceed immediately to a youthful offender consideration hearing under section 5283. That's what I just mentioned, right? That's step 2. That would ordinarily be that second hearing that would have to take place. This says, well, wait a second, if the court right away is of the view that youthful offender treatment may be amenable, then they can proceed to that youthful consideration hearing immediately. And at that hearing, the court, and this is also crucial to the findings that we just looked at, the court may rely on findings and evidence presented in the juvenile transfer hearing. So in other words, it doesn't have to rely on, I'll just take you for a moment to look at this so if you can see it. Well, actually, we'll come back to that. That's also helpful. So that screen on the right hand is disrupting my ability to protection. Can you move it down? Thank you. Oops, not that. I'm going to hold it with one hand. There we go. So you'll see this youthful offender hearing, this is existing law, also has this list of criteria that the court's supposed to consider. Almost exactly the same as the criteria that are in the transfer hearing that has to take place in the first instance. So what this proposal says is, well, you don't have to do a separate hearing. Look at those other criteria again. See, it even says at the end, the court may rely on evidence presented in the juvenile transfer hearing, in addition to any further evidence, and the court shall not be required to consider the criteria of 5284A. That's the criteria of the youthful offender consideration hearing. So the idea is to try and reduce this duplicitous so that court can do all this in the first instance, doesn't have to go up to the criminal division, have a separate motion, separate hearing. In a sense, Senator Sears, it's sort of like when you mentioned the curtain issue, the way to approach it. You're already there. If it looks like it's a situation where the child is amenable to treatment as a youthful offender, the court could proceed right to it. And that's the idea. This will take us to the diagram. As I'll mention, last Friday when the committee was discussing this, Judge Davenport was listening on YouTube, and she helpfully pulled up this diagram to show how this would work. And you'll see, so this is the first step. Number 1 is the first hearing. This is in the family division. Somebody files a motion to transfer.
Eric, sorry to interrupt you. I just see Lindy's hand is up in the Zoom room.
Oh, sorry.
Yeah. Hi, for the record, Lindy Boudreau from DCF. I'm the Juvenile Justice Director. My concern about this language from the department's perspective is two crucial components would be missing if we followed this procedure. The first is we have the youth assessment screening instrument that we do with each youth who's referred, or offer at least, and to each youth who's referred for youthful offender status. That's really our ability for 2 things. One, there's the presumption of diversion language in the youthful offender statute, and that's how we make the determination about whether or not we're going to recommend diversion, and the state's attorney has the ability to overcome that presumption. But that's how we use that tool, and this would not allow for that process to happen. In addition, it also we would be missing the opportunity to interview the youth in the collateral context to help inform the court about the pieces of information that are in the consideration report currently. And so in the hearing now, the department files a report to the court to help inform the 3 questions that are in statute and the information that you just provided, Eric, related to information and background to support the recommendation. So with this proposal, both of those pieces would be missing from the process, and we're concerned about not being able to have an informed process.
Questions?
If I could, I'd like to just echo those concerns from our
Hold on
perspective.
just a moment. I recognize somebody else.
I think just picking up on those concerns, I had a conversation with Judge Zone about this, and he had recognized exactly the same concerns that, and his suggestion was that we just simply slip that language right into the first part of the hearing, so that when there's a motion to waive up, that there is, that all of that collateral work by DCF is done. And that should actually be done anyway, honestly, for the motion to waive up. I mean, it's, when we're talking about, you know, the information that Ms. Boudreau talked about is actually very important information. We've come to really value the information provided by the YASI as have the courts, and the courts have really come to value the collateral information provided by DCF when they do their youthful offender consideration reports. Currently, there is no process for DCF to provide that information in a transfer up hearing anyway. So right now we're talking about a process where kids currently get transferred up to adult court without any of that information at all. And honestly, it should be there. Judges should have that information not only when they're making the youthful offender determination, but also when they're making the motion to waive up. So from our perspective, that's actually a very easy fix. And we just add to the motion to waive up statute that DCF will prepare the YASI and do the same youthful offender consideration report that they do in a youthful offender consideration case. And frankly, from our perspective, that doesn't just help solve this ping pong problem. It actually adds more integrity to the transfer up process in the first place, because right now the transfer up process does not have that built-in YASI and DCF input.
Eric?
Just a quick question on that. Since I'm going to assume that adding that process to the transfer up proceeding generally would probably expand the use of the process because there'd be other transfer up cases, would another possibility be to add, to do what you're saying, add the youthful offender screening and report stuff just to the youthful offender piece that we're proposing to add? In other words, you could, another option might be just add to right in where it says the court may proceed to youthful offender consideration hearing, add in something that cross-references that screening report and say that would be required in this instance as well.
Right, I think the problem with that would probably come up if, because if DCF is not aware, like if DCF is aware that they have to do that every time there's a transfer up hearing, then it will always be done if there's a transfer up hearing that proceeds immediately into a youthful offender consideration hearing. If they were not aware that the hearing was going to proceed directly from transfer up into youthful offender, then they wouldn't have done that work by then.
So it would take a little longer.
Right.
I see.
So it would create, or what we're trying to do here is collapse 2 hearings into one and allow the judge to simply rely on the evidence and findings that were presented in the first hearing. That would really require a second hearing.
Yeah, so sorry, this is Lindy again, just to clarify, it would be if I'm concerned about having to do a report for every case that's going to be recommended to be transferred up, unless it's going to be transferred up for the purpose of YO consideration. I would suggest that we add language, because if they're transferring up and there's no intention for the case to come back to family division for youthful offender consideration, it's going to be an additional lift for the department to report on every case that's transferred out.
I'm going to ask that Marshall and DCF and Eric and Jared or Tim work together to come up with a language for this next week. We're not going to get through this bill this week.
Your
Senator Paul.
I'm waiting for my only vacation that in the last few years on Friday, and I'm not picking up my phone.
Oh, okay.
Well, I'll be back on town meeting day, but I'm just
That
saying.
won't do us any good.
It won't be, like, I actually have to be gone for a week, so.
Okay.
Well, there's between now and Friday.
Yes.
Can you do that if I rearrange the agenda for tomorrow? Can you get something to us by tomorrow? And Eric, are you free?
I'm free in the morning, yep, tomorrow morning.
Which is better for you? 30. Saying he's gonna have to notify some witnesses.
Is 10:45 still good for you?
Yep.
Yeah, we talked about it earlier, 10:45.
Okay, why don't we pick up with S4 at 10:45? I know Senator Baruth won't be with us, but we'll see what we can do. Since you won't be here till town meeting, and I don't want the bill hanging out here after town meeting. Okay. So unfortunately, we'll just move bail to next week. I think we've already heard. We really don't need Michelle again to testify. We just need her to be here.
Yep.
So see when she's available next week. Those additional opposed steps. Hopefully that doesn't screw people up. All right.
So that probably, with that last issue, is sort of the potential way to work in the screening and report issue. Is there any more you want to talk about this subject before moving on to some of the rest of the bill, or what?
No, why don't we go on to section 4?
All right. Right, yeah, so there's no changes, I don't think, to the.
Well, we're gonna change human trafficking to 16-year-olds. In that big 10, big 12,
Right.
big 19.
Yeah. But no changes to the underlying offenses in 3 and 4. I don't oh, sorry, in section 4, when we get to defacing the serial number, there is, remember the penalty, the fine issue had been discussed last time, and you went from 100,000 to 50,000.
Yep.
In the straw purchasing piece, this is an option to think about in addition to the same fine change that we just mentioned on line 17, 100,000 to 50,000. This is the issue that Senator Hashim had been concerned about in particular, and the committee's been discussing about the presence of the word demand in the offense and whether or not the demand of another person could be sort of coercive or threatening to a person, and that's why they bought the firearm on behalf of somebody else. So possible language to think about based on the criminal law does have an existing defense, so that there's an implied defense that coercion or threats.
Okay. Is this applied to the person who, obviously it applies to the person who's buying the gun, does it all apply to the person who is getting the gun?
I don't think it does.
Yeah, I think this is only an offense by the person who's doing the purchasing, the straw purchaser. But the receipt of a stolen receipt of a firearm unlawfully, that person, as soon as they receive it, if they're a prohibited person, they're committing a felony just by having it.
All right, thank you.
Yep.
Can I suggest, if we're going to keep subsection B highlighted, I wonder if we shouldn't eliminate demand above, because we're saying sort of opposed things there. We're saying it's an offense to do it under a demand, but then below, if you're not going to be prosecuted if it's due to threats or coercion, I would view a demand as.
I think you're right.
Yeah. So the proposal would be to get rid of the highlighted word demand on line 7.
But keep the B.
Yeah.
Right.
I certainly support that.
I'm on both sides. I get stopped, but I went into this store in Rutland that I always go to use the metro. Some guy asked me if I was a Democrat or Republican, and I said Democrat, and I realized I should have said both.
Right. Somebody on your way to the bathroom, somebody just asked you what party?
Well, they saw the car.
Oh, I see. I had a guy in New Hampshire saw my plate and came out and at the time I was driving a Honda, and he said, "I can't believe you're in elected office and you're driving a non-American car, and I said, well, I'm from Vermont, we don't disqualify people on what our cars are. But it was weird, just walked up.
So I know people have known it, but somebody said that about a Nissan once.
Yeah.
And the response is the steering wheel was made in Bennington, so. Anyhow,
Alright, so I have, I'll
I
make
think
that
that's
change.
probably
Yep, that makes sense.
another win for Senator
That's what it is. All right, moving on to section 6. This is the addition to the prohibited persons list. A new list of folks to try and conform the list of prohibited persons with federal law. Remember, there are a couple of issues here. I'll do the more straightforward one first. This is line 15. Remember, that was the issue of, well, if charges are against someone, have been filed against someone, the way I had written previously, it sort of carried the implication that, well, it doesn't matter if the charges have been dropped. If they've ever been filed against the person, they would be prohibited. And that is certainly not the way the federal law works, because federal law is under indictment. So if they're no longer under indictment, then they wouldn't be prohibited under federal law either. So here it's a similar idea. It's against whom charges are pending for. So if the charges are pending, then they're prohibited.
I just got a quick question on this one here. I don't have a problem with the way that it reads, but obviously we just went through a 2 to 3 year pandemic. And against whom charges are pending. I mean, we don't know what's going to happen in the future. Obviously, they're going to just, could they be pending with our court backlog for 2 and 3 years? I mean,
I think that's a fair assumption, that it could be.
Oh,
Are you saying you,
I'm just wondering if some other way we could address that. That's all. In case we, for whatever strange reason, I mean, I know we're working on cleaning up the backlog of court cases or whatever else, but
yeah, I don't know how you do that other than putting a time limit, but
you could make it effective at a later date, this particular section.
to make sure
Year
the
from now, hopefully backlogs will be. I mean, you can make it any date you'd like.
I mean, I'm not opposed to it.
Just change the effective date.
But if they're innocent, I mean,
So that, this
Yeah.
doesn't become effective until we can get an idea from Judge Zone of when we may get back to a more normal backlog,
I just had a question.
or
about-
no longer than a year.
Yeah. On line 13, it's a fine order against stalking. I know elsewhere in the bill, we have aggravated stalking. Is that drawn in here?
Yes,
Okay.
that would be included. But that segues me into the stalking issue, because there's another issue related to stalking and the RFA orders, which the committee, I think, had started to talk about a little bit last time. And Judge Zoni had brought it up. So the issue is that the stalking in the context that the term is used in Vermont doesn't apply to just stalking between family members and household members. It could apply, for example, between neighbors, that sort of thing. And that sort of would be slightly broader than what the federal prohibitor language includes. And again, policy decision for you, but just important to understand which way you want to go. So whereas intimate partner stalking or family member stalking, that is covered actually by the relief from abuse order, which is interesting in that, just look at that language for a moment. So this is what is the predicate for a relief from abuse order is stalking. So if you are stalking between family members or household members, it would be a relief from abuse order. Interestingly enough, which I didn't realize, in order to get a stalking order for a non-family or household member, it has to be a relief from abuse order. And the stalking statute specifically says a person other than a family or household member may seek an order against stalking sexual assault on behalf of himself or herself. So it would have to be somebody other than a family or household member who would be covered by the civil stalking. Now, that may be what you want, but just good to understand how they both work.
Yes.
This was a point last time that I made some notes on because we ran out of time, but I think my concern, I want to thread this needle and really not be wading into neighbor disputes. And I don't think that intimate partner stalking is the only time in which stalking is actually incredibly dangerous. You know, we could be talking about the stalking of a public figure. We could be talking about the, like, and again, it's sort of.
Hospital staff.
Hospital staff. So while I want to thread the needle, the language that we seem to have available to us, and Eric, maybe I'm wrong, maybe there is a way to thread this more carefully, doesn't seem to cover all instances in which stalking actually could be incredibly dangerous behavior and is not just a dispute between neighbors. So I don't know if there's other language or a way to capture all of the instances in which stalking rises above a neighborhood conflict.
Honestly, I couldn't think of one, only because we would have to come up with a defined term of some sort, I guess.
Mhm.
You know, because right now, the household members, as you were mentioning, what their stalking that is swept into a relief from abuse order covers family members, household members. And those are more intimate, another way to look at it, intimate partner situations, they dated, although it does also apply to anybody who does apply to roommates, for example, who haven't necessarily had a dating relationship. But beyond that, you're right, there's this other area. And I'm not sure how you define that.
Yeah, there's all kinds of stalking cases. Maybe. I think we need to come back to this.
I think you had a good sense of what the issue is.
Yeah.
Right? And all right, so let's pass over that one for now, and continue on to the. This is the piece now. We're coming into the section that involves carrying a dangerous weapon while committing a felony. Now remember, there's a piece. The only change, there was no change to the underlying statute here. It was just a similar change that had been made in several other places. That the offense would be considered, at least with respect to carrying a firearm while committing a felony, would be considered a violent act for the purposes of whether a person is eligible for bail. Remember? So that was what the proposal was. But there's been concern about, well, what about, because there are some felonies that involve property only. And some of those felonies depend on how much value is in the property as to whether or not it's a misdemeanor or felony. So I propose some language here to think about that might cover that. And this is in subdivision 2, line 16 to 18. An offense that is a felony instead of a misdemeanor solely because of the monetary value of the property involved shall not be considered a violent act under this subsection. So that way it sort of excludes that universe. If that's the only reason, then it's because it was $950 instead of $850, because as it happens, $900 is the threshold in a lot of those cases. Then it wouldn't be considered a violent act. So that's one possible way to thread the needle.
Okay, section 8.
All right. Section 8.
Why don't we jump back to this after Senator Baruch gets back?
Okay. Yeah.
Because, major
Yes. So that would take us to section 10.
and
So this is the new language that I think the Department of Health proposed, right? Regarding the community violence prevention program. Just with some different criteria and standards, but I think keeps the general purpose and idea of the program. It sort of retitles it community violence prevention. So that's the overall title of what the grant program is. It's in the Department of Health in consultation with DPS, Violence Prevention, Executive Director for Racial Equity. Program works with communities to implement innovative evidence-based, evidence-informed programs addressing youth and community violence. Commissioner of Health awards the grants. Now, also, one change too, you may recall, line 1, it's not just the municipality, it's other organizations as well can submit applications for these grants. Commissioner of Health.
That was a change by the administration.
Yes, yep, it's line 1, municipality or organization, subsection B, they submit an application.
Should it be I'm gonna ask the Agency of Human Services, somebody's here, Department of Health, should it be a nonprofit organization or could it be IBM?
Question. Certainly framed broadly the way it's written.
Yeah, did I see? Is anybody from AHS? Why don't we ask? I'd feel more comfortable if it was nonprofit.
Well, we can add it for the next draft anyway, and see if we give any feedback from anybody.
Oh, Senator Sears, this is Jay Pershing Johnson speaking. I don't feel strongly one way or the other. I think municipality is fine. The goal obviously is to do something like we're currently working on in Bennington, which is to sort of identify community resources, and those are largely state and community resources. So I don't believe that, I mean, I don't feel strongly that it would be an organization. I mean, it could just be municipalities, because I think that was the initial goal, is that we're working on a project that's replicable statewide, where communities can bring together law enforcement and social service resources to reduce violent crime in our communities.
Evidently, the Agency of Human Services or DCF, some Department of Health wanted an organization, and I just prefer that it be a nonprofit organization personally.
Yeah, and I wouldn't object to that.
Okay.
I mean, however you were looking to frame it, but it could be municipality or nonprofit.
Yeah. Like if the local hospital wanted to do a grant, it would be eligible.
You're right.
Okay.
All right, so the Department of Health has to develop and publish guidelines for the award of the grants. That's subdivision 2. They also collect data and monitor youth and community violence under subsection C in order to evaluate the impact of prevention efforts, use the data to plan and implement programs. There's additional language that statewide strategies organized by the Department of Health, what they may include technical assistance contracts, statewide evaluation program, or other strategies that benefit grantees and enhance the effectiveness of the program. $10 million appropriation is still the same. There's some language added that unexpended appropriations can carry forward. Authorizing the Department of Health to seek and accept grant funding as well. And that's other than that, it's the same as very similar idea as I mentioned to what you were looking at originally.
Yeah, I don't see it's changed dramatically. Just gives a little more clarity to that.
Sounds good. All right, so sections 12 and 13. This is the delayed effective date of the Raise the Age program. Remember the last time the committee had talked about this, I don't know if you had landed on a final time, but this sort of for discussion purposes anyway, you're looking at a 1 year delay until July 1st, 2024.
Okay. Any comment on that? Anyone in the room or?
Next, then, is related to that, Senator, you mentioned it earlier at the beginning of the hearing, the plan for secure placements. This is obviously connected to the delayed implementation of Raise the Age, because this says that DCF will file status reports with joint legislative justice oversight and the Judiciary committees on their progress made toward implementing this Raise the Age requirement. So they would be 2 separate implementation reports, September and December. Section 15 I mentioned earlier as well. This is the Sentencing Commission report on, remember the offenses that had been proposed to include the Big 12 but you had accepted some, those that you decided not to include in the new Big 12 list yet, you would have the Sentencing Commission look at those in more detail and make a recommendation as to whether these ought to be added to the Big 12 as well. And last new section, section 16, this is severability. This is essentially means that if one section of the bill is found to be invalid, maybe because it was unconstitutional or for whatever reason, that doesn't affect the other sections of the bill. I should add that there is a severability section in law that's cross-referenced on line 14 there, 1 VSA 215, that applies across the board. So this severability provision would apply whether or not you have the section here. But I think the committee thought that it might help with comfort level, and I spoke with Jennifer Carvey and Michael Grady about that. And they said as long as it was understood that this is rarely done, generally done only when there's really an anticipation of litigation, which in this case is qualifies.
Yes. Sections here that.
Right.
Actually 4 sections that 3 are probably less controversial than the 4th, which is section 8.
Right. So that's what that does. It makes clear that if section 8 or whatever other section was found unconstitutional, it doesn't affect the other section of the bill. So other than.
Can you check and see if Senator Booth is still in back?
Sure.
We're down to section 8.
So I think, other than section 8, Senator Seer, we've got a little bit of new language in the very first section on, we changed the human trafficking 16 and over. Some clarifying language on the condition of release on page 3. We're going to coming back to the ping pong issue and coming back to the issue of stalking. But I think that's it.
Yeah, I'm not sure. How broad can stalking be?
Let's see, pull that up. Well, the civil stalking, I think it uses the same definition. So you see the definition of stalk. Purposely engaged in a course of conduct directed at a specific person that the person engaging in the conduct knows or should know would cause a reasonable person to fear for their safety or the safety of another, or would cause a reasonable person substantial emotional distress. And course of conduct is itself defined above. 2 or more acts over a period of time. The person follows, monitors, surveys, threatens, or makes threats about another person, or interferes with another person's property. Shall apply to act conducted by the person directly or indirectly by any action, method, device, or means. I think that's intended to include electronic devices.
So there's always a case of Bennington. The candidate, I'm a candidate for governor, state senate, and everything else, are at town meeting during voting or at the primary voting, I can't remember which. One is taking pictures of the other with his cell phone. And the other one starts taking pictures of the one taking the pictures. Then they get into a beef and start hitting each other's cell phones. These are adults, by the way. Make that clear. So they each go to court to get a non-stalking order. get protection. So they both have stalking items against each other. And one of the requirements is they not do anything on social media to the other. And so turns out, that one of them does continue to do it. So there's an arrest warrant out for it. Hasn't been resolved yet. But I'm just curious as to, do we want to take their guns away? On the other hand, it's serious stalking and should we go to aggravated stalking? Is there an aggravated stalking? Yes, no, I thought there was.
There's a criminal aggravated stalking.
Criminal what?
I think there's a criminal charge for aggravated stalking.
Senator Sears, may I add something?
Yeah.
For the record, Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And as both you, Senator, and Attorney Fitzpatrick have highlighted, the primary difference between these two kinds of orders is whether someone does or does not fit into the household member definition. And, we support including both types of orders in the bill as drafted. And I just kind of wanted to note that non-household member sexual assault or stalking could include circumstances such as an acquaintance sexual assault where there was no previous dating relationship. Those people would not be household members. Stalking where one party is dangerously infatuated with another person, but there was not a previous dating relationship. So, there is really very dangerous behavior that is encompassed under the civil sexual assault and stalking orders, even when the two parties do not qualify as household members.
Why don't we move on to, thank you very much. We'll need to come back to this tomorrow at 10:45. But Senator Baruth, we were going to go through section 8, but you weren't here. So I thought we'd hold on.
Yeah, I appreciate it. I have thought a lot about this section. As you know, we already have a prohibition on purchasing under 21, and there are 4 carve-outs. This was attempting to get rid of those carve-outs, or 2 of them, for semi-automatic weapons. I have realized through taking testimony that we've had a lot of misperception of what we're doing. People feel as though the intent is to prohibit assault weapons. And I realize it's partially because it's narrowing in on such a tiny stream of people. So after much thought, I am going to suggest that we pull this section. I think, among other things, it has a tendency to be a drag on the rest of the bill. I think it's also probably the most liable to face court challenge and direct the court challenge to the under 21 prohibition as it currently is. So with all of that said, although I was hoping we could do something, even if it was a small move on semi-automatic weapons, since it was my section, I would propose eliminating it with the intention of coming back at another time with something that might be simpler and more easily understood.
Good with that. That seems to be I think you're right that it's the piece that's probably the most ripe for a court challenge if it gets passed and signed by the government. But I think it's also has drawn a lot of critique and a lot of misunderstanding about really what it does.
Yeah.
I think it either could be as a separate bill or when we take up the House bills, if they come over. That we could discuss it then, maybe find a different way to. Yes.
I just have a question. So removing section 8 from this bill doesn't take us backward in what's already.
Right.
Okay.
Right. So there would still be the under 21 prohibition, but the more carve-outs, being law enforcement, military, hunter safety course, transfer from a family member, those would remain in place unaffected by this section.
Is there any objection?
I certainly don't object to removal of section 8. That was probably one of the largest determining factors as to which way I was leaning on this particular bill. We put a lot of time, effort, and taken a lot of testimony on. And so with the removal of section 8, clearly that's, I think it's a very positive change for this bill.
Sorry, I had to step out for a minute.
Okay.
But if we're talking about removing section 8, I was weighing it a lot in my mind. I understand why it's something that's kind of slowing down the bill because there's things that need to be fleshed out a bit more. I do hope that it's something that we can come back and revisit as soon as possible. I have my concerns. When I was reading, I believe we've had more mass shootings in this country than there have been days in this year so far. And so it's with unease that I do support removing it for now, but I'd like to revisit some sort of measures that we can take as soon as we can.
And I think one of the things that I hope is going to come from the House would do that, at least one of them. Again, the number, because this is only targeting the carve-outs in the existing law, I think the number of weapons that it would affect is so small that in the balance, it doesn't seem to be worth the amount of effort we would expend and potentially draw veto over that one section. So I hear you. I want to act now to stop mass shootings. If I thought that this was the tool we needed, I'd fight tooth and nail for it. But I think it would be useful, but on a very limited scale.
Yeah, I see that, and it is very narrow, but yeah, I agree.
As one of the sponsors of the bill with section 8 in it, I don't have a problem taking it out, but also I agree that we need to look at what can we do. What kind of measures will help the situation that we find ourselves in? People that say it can't happen in Vermont or as it stands, in my opinion, it can happen here easily. And sometimes we've been lucky that they've been stopped before they get to that point.
I think I said in the same space as Senator Hashim and Senator Sears and Senator Baruch that it is narrow and sort of slowing this down, but I do hold considerable concern. I don't think it is a matter of if it can happen here, but when it happens here, if we're not taking proactive action. And so, yes, I sort of reluctantly support, just based on all the facts, given that it is such a narrow group and that but I really do want to advocate that we take up conversation about what we can do. I know we've heard some testimony that we really can't do anything, but I just can't sit with that. We can't do anything to help prevent mass violence in our communities.
And again, the other bodies moving pieces toward us that are also directed at this problem. So, the year is young yet. So
some days it sure doesn't feel like it.
No, today doesn't feel like
it does not at all.
So Eric, if you have a redraft ready for tomorrow.
Yeah.
economic development.
You have to go to economic development. Good, I hope it develops.
Develop in the con.
So we'll adjourn and have a final draft. And try to vote it out unless you
We can
can't
think
work
about
out.
Think about the
unless we-
stocking issue as well. I know there was some testimony at the end on that, or
Yeah,
keep it in.
I think I'm inclined to ask what are the numbers? I mean, we looked at the numbers for domestic assault, were huge, and I've got them somewhere in my file. I don't remember stalking in this age group being a huge.
Well, it's not an age group issue in the bill.
Oh, that's right.
It's only, it's a prohibited person.
Right.
Subject to a stocking order.
We'll have to make it.
Well, I'll keep it highlighted and mull it over tomorrow.
Yeah, with the ping pong, if we can work that out too.
We'll go offline.
Does anybody have a comment before we go offline?
Should I stop sharing my screen possibly as well?
Yeah, because it's been hard to see you. I guess so. Well, thank you very much for joining us online.